I am Dr. Sangeeta Roy Moitra under the West Bengal Education Service. Currently, I am posted at Hooghly Mohsin College, Chinsura, Hooghly. Today, I shall be speaking on social and legal measures to control environmental crime. The objectives of this paper are to make the learners understand the notion of environmental crime as a socio-economic offense, to make the learners understand the various kinds of environmental crime recognized by the international bodies, to acquaint the learners with the existing mechanism of environmental crime in India, to acquaint the learners with social and legal measures undertaken so far, to make the learners understand how to address the issue in the legal context. Environmental crime, the concept. Environment simply means surroundings. The Environment Protection Act 1986 defines environment as environment includes water, air and land and the interrelationship which exists among and between water, air and land and human beings, other living creatures, plants, microorganisms and property. The industry are the sources of hazardous emissions and effluents. The use of chemical insecticides and pesticides in agriculture also leaves dangerous residues. Transport, whether by land or water or air, contaminate the environment. Public health infrastructure, sewage, garbage and drainage has a detrimental impact on the environment. The term crime may be understood to mean whose acts which people in society consider worthy of serious condemnation. Crime is said to be an act which is both forbidden by law and against the moral sentiments of the society. Environmental crime is considered to be a socio-economic offense. Although the definition of environmental crime is not universally agreed, it is often understood as a collective term to describe illegal activities harming the environment and aimed at benefiting individuals or groups or companies from the exploitation of damage to trade or theft of natural resources, including serious crimes and transnational organized crime. Environmental crime also include corporate crime in the forestry sector, illegal exploitation and sale of gold and minerals, illegal fisheries or fishing, trafficking in hazardous waste and chemicals, and threat finance using wealth generated illegally from the natural resources to support non-state armed groups and terrorism. Environmental crime is considered to be one type of white collar or corporate crime. The government, the media and the public rarely conceptualize environmental harm and injustice as crime despite overwhelming evidence to the contrary. Research suggests that environmental crime causes more illness, injury and death than street crime. Despite overwhelming evidence that environmental crime is responsible for a great deal of harm to the environment and human health, the vast majority of the public is unaware of or ignorant to this type of crime. However, 5 broad areas of offences have been recognized by bodies such as the G8, Interpol, EU, UN Environment Programme and the UN Interregional Crime and Justice Research Institute. These are illegal trade in wildlife in contravention to the 1973 Washington Convention on International Trade in Endangered Species of Fauna and Flora or CITES, illegal trade in ozone depleting substances in contravention to the 1987 Montreal Protocol on substances that deplete the ozone layer, dumping and illegal transport of various kinds of hazardous waste in contravention to the 1989 Basel Convention on the Control of Transboundary Movement of Hazardous Wastes and Other Wastes and Their Disposal, illegal, unregulated and unreported fishing in contravention to controls imposed by various regional fisheries management organizations, illegal logging and trade in timber when timber is harvested or transported, brought or solid in violation of national laws. Other environmental offences may share similar characteristics with these 5 accepted categories. These include biopiracy and transport of controlled biological or genetically modified material, a possible offense under the 2000 Cartagena Protocol on Biosafety to the Biodiversity Convention. Illegal dumping of oil and other waste in oceans, that is offences under the 1973 International Convention on the Prevention of Pollution from Ships, MARPOL, and the 1972 London Convention on Dumping. Violations of potential trade restrictions under the 1998 Rotterdam Convention on the prior informed consent procedure for certain hazardous chemicals and pesticides in international trade in chemicals in contravention to the 2001 Stockholm Convention on persistent organic pollutants, fuel smuggling to avoid taxes or future controls on carbon emissions. Hence, what can be deduced is that environmental crime refers to the violation of laws intended to protect the environment and human health. There are two victims of this crime: people and environment. Environmental crime covers a wide range of violations that result in harm befalling the environment and human life, from errors at the administrative or record keeping level to the actual illegal dumping of pollutants into the environment. Principally, 5 areas are considered to be of major importance: illegal trade in wildlife, illegal logging and its associated timber trade, illegal unreported and unregulated fishing, illegal trade in controlled chemicals including ozone depleting substances, and the illegal disposal of hazardous waste. New types of environmental crime are also emerging, for example in carbon trade, water management, amongst others. Social measures. Social measures, as mentioned above, have been mainly in the form of ecological movements that have erupted wherever there have been threats to forests and agriculture lands by inundation, waterlogging, salinity resulting from the construction of large dams and massive projects. The genesis of concern for environmental protection in India can be traced back to the early 20th century, when people protested against the commercialization of forest resources during the British colonial period. It was only in the 1970s a coherent and relatively organized awareness of the ecological impact of state monolithic development process started to develop, to grow into a fully fledged understanding of the limited nature of natural resources and to prevent the depletion of natural resources. A large number of environmental movements have emerged in India, especially after 1970s and 1980s. In India, the environmental movement has grown rapidly over the last 3 to 4 decades. It has played a key role in 3 areas, such as in creating public awareness about the importance of the bringing about balance between environment and development. Secondly, in opposing developmental projects that are inimical to social and environmental concerns. And thirdly, in organizing model projects that show the way forward towards non-bureaucratic and participatory community-based natural resource management systems. Major reasons of the emergence of environmental movements in India include reasons such as control over natural resources, false development policies of the government, socio-economic reasons, environmental degradation, destruction and spread of environmental awareness, and media. Legal measures. Illegal trade in wildlife. Wildlife trade is the biggest threat to wildlife preservation. The rampant poaching in wildlife and its products are primarily driven by demands in the international markets. Dead and living animals are traded for a number of purposes, including food, clothing, ornaments and exhibition in zoos, research, medicines and the trophies. With significant profit margins to be made, the illegal trade in wildlife is flourishing, and even the so-called legal wildlife trade is rife with corruption and blatant disregard for both international and national laws. The protection of wildlife is included in the directive principles of state policy under the Constitution 42nd Amendment Act 1976. Under Article 48A, the state shall endeavour to protect and improve the environment and to safeguard the forests and wildlife of the country. Under Article 51AG of the Constitution, it is the fundamental duty of every citizen to protect and improve the natural environment, including various lakes, rivers, and wildlife, and to have compassion for living creatures. The most significant legislation on wildlife protection, which is based on the ecosystem approach and a regulatory framework, is the Wildlife Protection Act 1972. In India, while the term wildlife trade is not specifically defined under the Wildlife Protection Act 1972, Chapter 5 of the Act specifically deals with trade or commerce in wild animals, animal articles, and trophies. Illegal wildlife trade, in simple terms, refers to sale or exchange of wild animals or plant resources, trades of which is prohibited under the law. This may involve live or dead animals or plants and their co-derivatives. The trade may be for pet or horticultural trades or trade in wild animals and other plant products such as skins, medicinal ingredients, tourist curios, timber, wild meat, and other food products sought after by the humans. The objectives of this enactment are as follows. Firstly, to have a uniform legislation on wildlife throughout the country. Secondly, to establish a network of protected areas, that is national parks and sanctuaries. And thirdly, to regulate illicit trade in wildlife and its products. It has to be noted that poaching of wildlife as an organized international illegal activity which generates massive amount of money. Widespread changes have been made by the Wildlife Protection Act 1986, Wildlife Protection Amendment Act 2002. A new chapter has been incorporated as Chapter 6A to deal with forfeiture of property derived from illegal hunting and trade. Apart from this act, the other two relevant legislations worth mentioning are Prevention of Cruelty to Animals Act 1960 and Biological Diversity Act 2002. Before the passing of the above mentioned acts, there were other laws in existence to protect wildlife. The Indian Penal Code 1860, though has no specific provision relating to wildlife, but it defines the term animal under section 47 and declares maiming, killing or animals as an offence and punishable under sections 428 and 429. The other relevant legislations were Elephant Preservation Act 1879 and the Forest Act 1927. Ozone depleting substances. India signed the Montreal Protocol on 17 September 1992. In 1993, the country program was prepared to phase out ODS in accordance with its National Industrial Development Strategy. The country program was developed through a unique cooperation of the industry and the government with the assistance from the United Nations Development Programme UNDP. The views of the corporate sector was incorporated through extensive consultations with 6 industry groups, namely aerosols, foams, halons, refrigeration and air conditioning solvents and chemical producing sector. In July 1999, the first phase out obligation applicable to developing countries came into effect. India, being one of the major manufacturers of ozone depleting substances, is now taking tremendous efforts to comply with or even exceed the phase out schedules of the Montreal Protocol and has developed strategies and regulations to achieve its goals. In India, per capita consumption of ODS is less than 3 grams, which is much below the 300 grams limit permitted under the Montreal Protocol. With respect to CFCs, currently India is the second largest CFC producer in the world after China. Today, India is self-sufficient in CFC and to a large extent in CTC. It has stopped production of MCF or methyl chloroform and halons since 1992 and 1998 respectively. Recently, India has also entered into an agreement to stop production of CTC. Compliance with the ODS phase-out provisions requires action to address both supply and demand. The supply of ODS will decrease once the major production plants are closed down and effective trade control and stringent border monitoring are in place. However, there is a huge demand for ODS in the servicing sector for air conditioning and freezers, and the risk of illegal trade arises where there is oversupply in the adjacent countries and there is a scarcity in the local markets. The major enactments dealing with the issue are Environment Protection Act 1986. Environment Protection Act 1986 gives powers to the central government to take necessary measures for protecting and improving environment as well as prevention, control and abatement of environment pollution. The ODS rules 2000 have been issued by the central government under the Environment Protection Act 1986. Ozone depleting substances regulation and control rules 2000. Ozone depleting substances regulation and control rules 2000 provide comprehensive control and monitoring regulations for production and use of ODS in India. These rules prohibit the use of CFCs in manufacturing various products beyond 2003 except in monitored dose inhaler and for other medicinal purposes. Similarly, use of halons is prohibited after 2001 except for servicing and essential use. Other ODS such as carbon tetrachloride and methyl chloroform and CFC for metered dose inhalers can be used up to 2010. Further, the use of methyl bromide has been allowed up to 1/1/2015. Since HCFCs are used as interim substitute to replace CFC, these are allowed to be used up to 2040. The rules also provide for compulsory registration of ODS producers, manufacturers of ODS based products, importers, exporters, stock list and sellers, and the same provision is applicable to manufacturers, importers and exporters of compressors. These rules also indicate specific phase out dates for manufacturing products using ODSs. Illicit trade in hazardous waste. India is a signatory to the Basel Convention. Therefore, the transboundary shipment of hazardous waste, as it is termed, is regulated by the convention. The waste management program reflect this reality. Import of hazardous waste is illegally prohibited in India. This being said, the import may be allowed for the purpose of recycling or recovery or reuse. The export of hazardous waste may be allowed to an actual user of the waste or operator of a disposal facility with the prior informed consent of the importing country to ensure environmentally sound management of the hazardous waste in question. Importing of hazardous waste for disposal is prohibited in India. The only purpose for which import may be allowed is for purpose of recycling, recovery and reuse. Different procedures are applicable before hazardous waste may be imported for the purpose of recycling, recovery or reuse. In India, the National Environment Policy 2006, while suggesting measures for controlling various forms of environmental pollution, lays emphasis on the need for collection and treatment systems for recycling waste and devising measures for environmentally safe disposal of residues in India. Waste management is governed by various subordinate legislations and the Ministry of Environment, Forest and Climate Change, Government of India, in conjunct with state pollution control boards of different states, administer the gamut of waste management regulations. In Indian waste management rules are founded on the principles of sustainable development, precautionary principle, as well as the polluter pays principle for damages and harm caused to the environment by its own acts, bearing the essence in mind and the increased levels of waste generation as byproducts of development. Various subordinate legislations for regulation of the manner of disposal and dealing with generated waste are made by Ministry of Environment and Forest under the umbrella law of Environment Protection Act 1986. India has a regulatory framework under the Environment Protection Act to manage hazardous waste, namely Hazardous Waste Management and Handling Rules 1989 as amended in 2000, 2003 and 2004. Draft hazardous and other waste management and transboundary movement rules were published in July 2015, inviting suggestions and objections. Finally, the ministry published the Hazardous and Other Waste Management and Transboundary Movement Rules 2016. In addition, there are rules for biomedical waste and lead acid batteries. The major responsibility for implementing the rules is with the central and the state pollution control boards. The ratification of Basel Convention by India shows the commitment of our country to solve the problem on the principles and basis stated in the said document. The decision stated to have been taken by 865 conference parties by consensus to ban all exports of hazardous waste from Organization for Economic Cooperation and Development to non-OECD countries immediately for disposal and in the beginning of the year 1998 for recycling are therefore required to be kept in view while considering the number of items to be banned. As per the Hazardous and Other Waste Management and Transboundary Movement Rules 2016, transboundary movement of hazardous waste has become part of ministry's sound environmental management approach. Illegal, unregulated and unreported fishing. In view of the prospective changes in the international law of the sea at UNCLOS 3, the Indian Parliament extended constitutional recognition to the new concept of the exclusive economic zone in May 1976. As a result, Article 297 of Chapter 3, Part 12 of the Constitution reads as follows: all lands, minerals and other things of value underlying the ocean within the territorial waters or the continental shelf or the exclusive economic zone of India shall vest in the Union and be held for the purpose of the Union. 3 months later, in August 1976, the Territorial Waters Continental Shelf Exclusive Economic Zone and Other Maritime Zones Act entered into force with the exception of Section 5 contiguous zone and Section 7 EEZ, which entered into force in January 1977. This act made provisions for 12 nautical miles of 24 millimeter of contiguous zones, 200 run-off continental shelf and 200 millimeter of EEZ, dramatically increasing India's responsibility from 83,200 square kilometer to some 2.2 to 2.8 million square kilometer area of sea or two-thirds of the total area of the land. In December 1982, India signed the Law of the Sea Convention, and after it came into force in November 1994 and ratified it along with the implementation of Part 11 in June 1995. Till June 1997, India was one of the 116 countries which had ratified UNCLOS. Moreover, the UN legal provisions for the extension of the continental shelf to 350 millimeter by the year 2004, if preliminary exploration of the extended area is completed, is expected to provide an additional area of about 1.5 million square kilometer. About 10-15% of the Indian population living in the coastal areas is engaged in fishing as the sole means of livelihood. The total catch of the marine fish in India, estimated at 2.7 million tons in 1994-95, is far less than the estimated sustained yield of approximately 4 million tons in the EZ. In view of the traditional non-mechanized nature of Indian fishing craft, the vast proportion of fishing is confined to territorial waters. The management of living resources up to the territorial waters is the sole responsibility of India's provincial governments, its 9 maritime provinces and 4 union territories comprising 59 districts. Through their fisheries acts, the central government can only provide guidelines to influence their legislation in order to ensure conformity with international norms and regulations. Fishing beyond territorial waters comes under the jurisdiction of the central government's Ministry of Food Processing MFP. India has also enacted a number of laws and regulations including the Marine Products Export Development Authority Act 1972, the Indian Coast Guard Act 1978, the Maritime Zones of the India Regulation of Fishing by Foreign Vessels Act 1981, the related rules of August 1982, the Environment Protection Act 1986, the Coastal Aquaculture Authority Act 2005, etc. The other central legislation which have important bearing on the fisheries sector include the Merchant Shipping Act 1958 and the Wildlife Protection Act 1973. However, there is still no law to regulate the Indian-owned fishing vessels operating in the EEZ. In November 1981, the Maritime Zones of India Regulation of Fishing by Foreign Vessels Act came into force. It laid down conditions under which foreign fishing vessels could operate in Indian maritime zones, clearly prohibiting fishing in territorial waters. Fines and other punishments to be imposed on those violating its provisions were also included. In view of protests from local fishermen, the government in early 1997 suspended the charter and leasing operations of foreign vessels, trawlers, as well as the granting of new licenses to joint ventures companies operating in the EEZ, thereby scrapping its deep sea fishing policy of 1991. The Indian Coast Guard, established in 1978 as a consequence of the Maritime Zones Act, is directly responsible for anti-poaching activities in the EEZ. The statutory duties of the service stress the enforcement of legislation in India's maritime zones. The statutory duties of the Coast Guard emphasize the protection of fishermen, including assistance at sea at time of distress, as well as measures for the safety of life and property at sea. The Maritime Zones of India (MZI) Regulation of Fishing by Foreign Vessels Act 1981 needs to be amended so as to take into account the CCRF and other legal instruments. India is yet to accede to the 1993 agreement to promote compliance with international conservation and management measures by fishing vessels on the high seas, compliance agreement, marine fisheries management for the fishery resources in the exclusive economic zone of India, including depleted stocks, will be formulated based on legal instruments. CCRF, including a national plan of action for fishing capacity, sharks, seabirds, and IUU fishing. Fisheries conservation models developed during the study will be useful for implementation of various schemes and policies for sustainable development of marine fisheries in India. Along with letter of permit policy must be scrapped immediately to check IUU fishing in India. Illegal logging. In India, the national and state governments are jointly responsible for the sustainable management of the forest resources. In a practical sense, the state forest departments act as the custodians of the public forest resources and as the forest authorities managing the forest resources on the basis of forest management plans that they submit to the central government. Often the state authorities also perform a commercial function, becoming involved in production, processing and trading through forest development corporations responsible for production within the public forest estate. The Indian Forest Act 1927 is the country's guiding forestry legislation sought to consolidate and preserve areas with forest cover or significant wildlife, to regulate movement and transit of forest products, and to levy duties on timber and other forest produce. In 2012, the Act was amended to include prohibition of fresh clearances in the forest and setting fire to a reserved forest. The Forest Conservation Act 1980 states that prior approval of the central government is essential for the diversion of the forest areas for the non-forestry purposes. Diversion of forest land is mostly allowed in order to meet the developmental needs for drinking water and irrigation projects, transmission lines, railways, roads, power projects, defense-related projects, and mining. The Act stipulates that compensatory afforestation must take place, and plans for catchment area treatment, biodiversity and wildlife conservation, rehabilitation, etc. must be submitted to the authority. The Forest Conservation Rules 1981, updated in 2003, were issued to regulate the rights of tribals on forest lands and guide the process of establishing productive village forest, the National Forest Policy 1988 was established to ensure compensatory afforestation, essential environmental safeguards, sustainable utilization, maintenance, restoration, and enhancement of forest areas. It stressed that forests should meet the sustainable requirements of people and was intended to decrease degradation by forest dwellers through better management. It also stipulates that industrial wood needs should be met increasingly by farm forestry. Its main implementing program is called Joint Forest Management, which proposed that villages may manage specific forest blocks in association with forest departments in order to provide for the basic needs of rural and tribal populations, increase forest productivity, improve the efficiency of forest product utilization, and minimizes the pressure on existing forests. The Compensatory Afforestation Fund Management and Planning Authority was established in 2009 as a national advisory council under the chairmanship of the Union Minister of Environment and Forest for the monitoring, technical assistance and evaluation of compensatory afforestation activities. It is meant to promote afforestation and regeneration activities as a way of compensating for forest land diverted to non-forest uses. National Afforestation Program scheme began in 2006 and aims to support the ongoing process of devolving forest protection management and development functions to decentralized institutions of Joint Forest Management Committee at the village level and Forest Development Agency at the forest division level. The overall objective of the scheme is to develop the forest resources with people's participation, with a focus on improving the livelihood of the forest fringe communities, especially the poor. The Scheduled Tribes and other traditional forest dwellers Recognition of Forest Rights Act 2006 concerns the rights of the forest dwelling communities to land and other resources and stipulates that companies, states should protect the existing rights and concessions of the forest dependent communities. Other national legislation and policy relevant to the forest include the Mines Act, the Environment Protection Act 1986, the National Conservation Strategy and Policy Statement on Environment and Development of 1992, which makes environment impact assessment mandatory for most development activities, the National Environment Policy of 2006, the Biological Diversity Act 2002. To sum up, mankind is placing huge pressure on many natural resources as a result of our expanding population and growing consumption, and so the legal harvesting and trade of fish, timber, and wildlife presents a challenge in itself. Clearly, efforts to reduce the consumption of resources are essential. However, this needs to go hand in hand with the management of resources if sustainable use is to be achieved. It is astonishing to see the growth rate of these crimes. This new area of criminality has diversified and skyrocketed to become the world's fourth largest crime sector in the few decades. Environmental crime has impacts beyond those posed by regular criminality. It increases the vulnerability of an already brittle planet. The resultant huge losses to our planet rob future generations of wealth, health, and well-being and on unparalleled scale. They also compromise our ability to achieve the sustainable development goals. An additional byproduct of environmental crime is that it undermines peace. It is not unexpected that the UN Security Council has recognized the serious threat to security posed by environmental crime, with UN reports pointing to armed groups and potentially even terrorists sustained through the spoils of this rising criminal industry. Environmental crime has social, economic, as well as health effects. In the Indian context, the key reason behind thriving environmental crime may be chiefly attributed to lack of sufficient sanctions and legal tools, lack of capacity and resources, lack of coordination, lack of data, trade liberalization and globalization, and above all, weak governance. The need is now to have a serious reconsideration of the existing laws, implement laws in relation to issues that have been covered by the legal system, and frame laws and plug the loopholes in cases of absence and inadequacy. Thank you.